Let's analyze an example of an exam of having 6 questions, out of which you shall answer 3. Negligence. Negligence is the breach of the duty of care owed by the defendant to the claimant, which results in damage to the claimant that is not too remote. So there are 5 requirements that must be established. And in a problem question, you will be required to discuss each of these requirements and establish that these 5 requirements are satisfied on the problem question given. Firstly, there must be a duty of care. Duty of care is quite complicated with the new reforms. Before it was easier to identify duty of care because there were established duty scenarios. There were some few relationships that automatically qualified for duty of care, but it's not as easy as before anymore, because possible reason why they have changed the law is because there are a lot more claims coming and to control the 5 days of liability. So now you will have to always apply the test of Caparo-Robinson in order to establish duty of care. Secondly, you need to establish that after duty of care exists, you have to establish that there is a breach of that duty. Thirdly, the breach caused recoverable damage, and claimant suffered damage due to the breach. And finally, the final requirement is that the scope is not too remote. The duty of care requirement. The traditional duty of care scenarios are one road user to another, solicitor to client, doctor to patient, manufacturer to consumer, employer to employee. However, you're still required to apply the case of Robinson, even if it fits into one of the recognized duty categories. What is Caparo test? That used to be the law before, but it has been reformed. The Caparo test is the following. Could the defendant have reasonably foreseen that his or her negligence would harm the claimant? Is there a sufficiently proximate relationship between the claimant and the defendant? Is it fair, just, and reasonable to impose a duty? Robinson test changed the last requirement since it was quite hard to decide whether or not it's fair, just, and reasonable to establish a duty of care. The courts decided to change that last requirement, and they said that basically instead of applying the third question, the courts will have to look at the previous cases, identify the similar case, and apply the precedent to the case at hand. So there is no single unitary test which can be applied in all cases to establish a duty of care. You cannot just simply decide whether or not it's fair, just, and reasonable to establish a duty of care. That's why the precedent has to be applied. Then it has to be, breach of duty has to be established. This is closely related to the standard of care and the degree of carefulness that the law expects an individual to take to avoid causing harm or injury to another individual. The general standard of care is objective, the reasonable person standard. However, expectations may occur. For example, where defendant is a child or exercising a special skill. Causation. There are 2 basic questions for causation, and both of these questions has to be answered affirmative in order for the causation to exist. Firstly, was the defendant's breach of duty or other tortious interventions a factual cause of the damage? And is the damage attributable to the defendant's breach of duty? The starting point would be whether the breach of duty was a but-for cause of the harm. So but-for test applies. But for the breach of duty of care, would the outcome still happen, basically? You can read the notes of causation on this link when you receive the slides. And finally, the remoteness requirement. You can read the notes here on remoteness. So basically, this is just to control the floodgates of liability and to make sure that it is the damage is not too remote to the breach of duty. So how do we approach a problem question of negligence? Firstly, you need to establish duty of care. You need to show that there is breach of duty. You need to apply the back-foot test for causation, and you need to discuss if the outcome is too remote from the breach. As long as all these 4 elements are discussed in detail and all the relevant cases are applied, you should be getting a high grade. However, an essay question is different. Here's the basic structure of how you should be answering essay questions, not in just tort, but on all the essay questions that you may get. For example, when deciding tort cases, legal formalism is more important as a factor for judges than it should. Discuss. This is a possible essay question you may get. So it would be recommended that you argue for and against the statement and you make arguments for and against the statement. For example, legal formalism should be important as a factor for judges, and that it should not be. So you analyze the topic on all possible angles and you make all possible arguments that can be made on this topic, applying all the main cases that you have covered on the course. All the arguments you make should be supporting either of the statements. So a good way to stay focused on the question and answer the question as it asks you would be, after making every single argument, ask yourself, am I arguing for or against the statement? Is this answering the question? Make sure that the arguments are relevant, because most of the students just get this part wrong. They become very explanatory and they just try to explain the relevant law instead of making arguments and answering the question. So it is very easy to get this part wrong. You should be advised that you should make arguments rather than just explain the law. Explaining the law will not get you even a pass, because the question is asking you to discuss critically the statement rather than just explain the law around it. Example problem question that you may get on tort is the following. Ambulance received a call about a person in need of this service at 3:15, but by mistake the caller gave a wrong address. When the ambulance crew employed by London Ambulance Service reached the wrong address given at 3:20, they found no one in need of their services, and they said it could be a false alarm and left. However, the controller at London Ambulance Station was concerned and tried to double check. She, however, had switched her phone off. The original caller, didn't answer. At 3:55, another passerby on the street where the victim was saw the person and called the ambulance again, and that time the ambulance came, but it was quite late. There was a strong chance that if the victim had been treated by the ambulance crew after receiving the first call, serious disabilities would have been avoided. How should we answer this question? Firstly, we need to assess if ambulance is under a duty of care. Traditionally, doctor-patient relationship automatically qualifies for duty of care, but that's not the case anymore after the recent developments of duty of care law. So now we still have to apply Capper-Robinson test, even if doctor-patient relationship used to be automatically qualifying for duty of care. So you should apply Robinson test, and the relevant case here is Kent versus Griffith. As we discussed, as Robinson established, we need to find the similar case with similar facts to apply in order to decide whether or not it's fair, just, and reasonable to establish a duty of care. The similar case that Robinson asked us to find is Kent versus Griffith. And Kent versus Griffith, ambulance service was negligent in failing to respond promptly. There was no reasonable excuse for the delay. The Bradford test was applied, and it was argued that there was breach of duty, but for the ambulance service negligence, the damage wouldn't have happened. Thus, it was not too remote, and damages were available. However, here the situation is a bit different. Here, the first phone call was received, and the wrong address was given, which was not ambulance services fault. So there could be breach, the break of the chain of causation. That's how it is called, legal term. This was different to Kent versus Griffith, where the correct address was given. So here, what we're doing is we're distinguishing the precedent that we have to apply, and we are justifying the grounds on which the precedent should not apply. In this case, and the precedent, Kent versus Griffith, the correct address was given, so the facts were different. Here, the wrong address was given at no fault of the ambulance service. So it could be argued that that was not the fault of the ambulance service, and they couldn't have reasonably foreseen that the wrong address was given. However, the fact that they just decided it was a false alarm gives us area of discussion. So we could argue that the crew team was under a duty to call the controller and double check. So this could be argued to be breach of duty of care, and this could be a reason why the chain of causation may not be broken. Not because the wrong address was given, but because they didn't double check. The victim would have suffered much less serious disabilities had the ambulance come on time. So Bradford test should be satisfied. In this case, the main controversy was the chain of causation, and you needed to apply relevant cases to establish whether or not there was breaking of chain of causation. So the conclusion would be that the London ambulance team did have a duty of care which had been breached, and damages may be available. After applying the case law, it would be a good practice if you go to our notes and make sure that there are no other cases that could strengthen your analysis. There are always more cases to mention, and if you have time on your exam or on your coursework, if you have space, it would always be better to see maybe that there are other cases you could mention. So where do you find cases? Firstly, on our notes, and secondly, on your lecture slides. Make sure you mention all the relevant case law. To conclude, you're not required to give a definite answer. You're required to identify all the arising issues, apply the applicable law, and provide detailed analysis. Most of the times, case law may be contradictory. They may suggest different outcomes. What do you do in this case? You discuss both of the possible outcomes, and then you conclude which outcome is most likely to happen and why. The next topic, nuisance. Nuisance may come as a problem or as a question, but more often it's a problem question. You can read our notes on nuisance at this link. A nuisance claim may help to safeguard against external interference with one's own property or any such intrusion affecting a wide section of the public. We have two kinds of nuisance, private and public. Public nuisance is actually a criminal offense, and it's actionable by action in general in the public interest, whereas private nuisance can be preservation of proprietary rights and interests which support the use of enjoyment of an individual's piece of land. So if somebody is interfering with your enjoyment of your own land in any way, that could be private nuisance that you can sue for. Private nuisance should be unreasonable use of land. So, for example, if your neighbor is using the land reasonably and you claim that is unreasonable, that it is nuisance, your claim may not be approved because they are using the land reasonably. However, if they're doing something that could be characterized as unreasonable behavior and it is disturbing your enjoyment of your land, that could be private nuisance. So the key point here is that the use of the land must be unreasonable by the defendant. The courts may consider the following factors to conclude whether the use of land was unreasonable, such as neighborhood character, claimant sensitivities, nuisance duration, potential public benefit, and defendant's malicious behavior. These are all important factors that needs to be considered when you provide analysis on private nuisance. And duration of the interference, if it happened only once, it may not be nuisance, but if it's happening regularly, there is more likelihood that it's a nuisance. You can have a look at this case, which is a case of private nuisance. In this case, claimant lives next to a cricket club, and despite of the 6-foot fence that was constructed to not disturb the people living there, and some balls still entered the rear gardens of the both claimant, and the defendants were guilty in both nuisance and negligence. So this is the example of the scenario that may happen in case of private nuisance cases. Public nuisance, there are two requirements. That firstly, there must be affected class of people by the nuisance, and secondly, special damage must have been caused to the claimant. This is the case for public nuisance, and it is highly recommended that you have a look at this case after the session when you receive the slides. Sending large number of separate postal packages to individual members of the public containing racist materials amounted to public nuisance in the case of Remington and Goldstein. So how do you find cases easily on our platform? This is a very important tool that you should be using. For example, you're writing a coursework on public nuisance and you want quickly to have all the cases available on our platform about public nuisance. How do you do that? Public nuisance you use as a keyword and you put it in the search bar like you see on the screenshot here. Public nuisance, and it will give you all the cases available containing the about public nuisance, and then you can read all the cases and use it for your coursework. Next topic that will most likely come up on your exam as a problem question is psychiatric harm. Psychiatric injury is not recoverable in negligence, but if a physical injury happens, it may also come with psychiatric injury, and both of them may be recoverable. And psychiatric injury claims, first thing you need to do is to identify whether or not the victim is primary or secondary. There are cases for you to identify whether or not it's primary or secondary, but the main difference is that if it's a primary victim in psychiatric injury, it's something that happened to you specifically as a result of an accident, for example. You were yourself in the accident then you were a primary victim. However, if you were a bystander of an accident, you just witnessed an accident, nothing actually happened to you, then you're a secondary victim. And the bystander law is more complicated. Primary victims always qualify for psychiatric injury claim. However, secondary victims, not always. They have to satisfy many requirements, as we will see afterwards. Primary victims cases could also be stress at work cases or people who are physically endangered. Important cases that you should read on psychiatric harm, both for primary and secondary victims, is Page versus Smith-Alcock case, which sets out the requirements for secondary victim cases, White versus Chief Constable of South Yorkshire, and White case 1901. This is especially important for secondary, in order for you to understand what is secondary victim and what are the requirements for you to establish whether or not someone is a secondary victim. It is set out in Alcock and White, these two cases. Finally, we're going to discuss very briefly what is defamation, and in the upcoming classes, we will go in more in-depth discussion of each of this topic to make sure that you attend all the classes. Defamation is a tort which preserves a person from reputational damage by excluding the publication of information expected to draw negative attention from others. So if somebody publishes a negative information about you, it can be defamation. However, if this negative information, which affects your reputation, is true, that can be a defense. So you may not be able to bring a claim on defamation. The Defamation Act 2013 is the main statute, and you have to apply the statute on a problem question in defamation. Defamation is the publication of an untrue statement. So if the statement is true, then it's not defamation, which reflects on a person's reputation and tends to lower him in the estimation of right-thinking members of society. To put it in simple terms, somebody publishes information about someone that makes that someone look very bad. But the most important is that the statement is untrue. Elements of claimant defamation, unless the action is one of which special damages are shown. At common law, the claimant in defamation action has needed to prove only the following three requirements. Defendant has published the statement in question with defamatory meaning and referring to the claimant. So as long as the statement was published by the defendant, it was defamatory in meaning, and if it was referring to the claimant, then it is set out. So the main controversy in the problem question that you're going to get for defamation that requires most of the discussion is the second requirement, whether or not the statement was defamatory. And there are many cases that you need to know about this in order to decide whether or not a statement can be characterized as defamatory or not. And whereas the first and third requirement are most of the times obvious. To sum up, you need to analyze your exam requirements and plan your studying accordingly. Many students do not plan their studying until the exams come close. Do not make this mistake, because studying law is very hard and it requires a lot of time as well as practicing. You not only have to study the topics and the cases and the key principles, but you have to also practice a lot to improve your legal writing skills. Knowing how to write how to answer problem and essay questions is not something you can learn in 1 or 2 days. It's a constant practice, and you have to be practicing all the time, as much as you can. Secondly, you need to do selective studying. Make sure you select the amount of topics you will most likely be required to know for your assessment specifically, and study those topics and then practice on those topics by answering problem and essay questions on the selected topics. And fourthly, Grading is subjective, so make sure that you know what your professor requires from you, the style that your professor wants you to write. The best way to do this is to draft problem and essay questions, the answer to problems and essay questions from past exam papers, and email it to your professor to get some feedback. There is also sometimes formative coursework, but you may not have it, or you may have it. If you have it, make sure you submit the formative coursework, because that's your chance to get some feedback from your professor, and that's a great opportunity for you to learn more about what you're required to do on your exam. How can we help? On our platform, we have simple study materials made by top students and graduates to teach the rest of the students what is the best way to study and what is the simplest way to get the highest grades. We have simple notes, model answers, tutorial videos, quizzes, flashcards, online classes like this, and study groups that you can join. Here are the links for tort law specifically. It's highly recommended that you read our notes, our cases, watch our tutorial videos, quizzes, practice with our quizzes and flashcards, and practice with our model essays. If our resources are not enough, you can practice with with our tutoring sessions, online classes, and you can book a one-to-one tutorial with us. As you can see on our reviews, we have already helped thousands of law students, and we would love you to be the next one. Please join Simple Studying via this link and join our study groups here.